Getting a divorce in Colorado is actually simpler than you might think. One spouse must be a resident of Colorado for 90 days before a divorce can be filed. Once the residency requirement is completed, a legal grounds for a divorce must be established. In Colorado, only no-fault divorce is acceptable for divorce. The sole no-fault reason for divorce in Colorado is irretrievable breakdown of the marriage. Colorado requires a parenting plan for child custody. Child custody is granted to either parent based on the best interests of the child, regardless of the sex of the parent. In determining these best interests, the court considers the preference of the child, the desire and ability of each parent to allow an open, loving, and frequent relationship between the child and the other parent, the wishes of the parents, the child's adjustment to his or her home, school, and community, the mental and physical health of the child and the parents, the relationship between the child and the parents and any siblings, any evidence of spouse or child abuse, whether a parent's past involvement with the child reflects a system of values, time commitment, and mutual support, the physical proximity of the parties to each other, and the ability of each party to place the needs of the child ahead of his or her own needs. Visitations may be restricted if there is potential danger to the child. However, joint custody may be awarded if both parents submit a reasonable custody plan. This plan should address the location of each parent, the periods of time during which each parent will have physical custody of the child, the legal residence of the child's education, the child's religious training, if any, the child's health care, finances to provide for the child's needs, holidays and vacations, and any other factors affecting the physical or emotional health or well-being of the child. Additionally, the following points should be considered in addition to the standard terms when seeking joint custody: the ability of the parents to cooperate and make decisions jointly, whether the past pattern of involvement of the parents with the child reflects a system of values and mutual support, which indicates the parents' ability as joint custodians to provide a positive and nourishing relationship with the child, and whether an award of joint custody will promote more frequent or continuing contact between the child and each of the parents. The court may order reasonable needed child support from either or both parents without regard to marital fault, after considering the financial resources of the child, the financial resources of the custodial parents, the standard of living the child would have enjoyed if the marriage had survived, the physical and emotional conditions and educational needs of the child, and the financial resources, needs, and obligations of both the non-custodial and the custodial parent. Provisions for medical insurance and medical care for any children may be ordered, and there are specific child support guidelines in the statute. These forms are available from the clerk of any district court, and child support payment requirements as well. Child support must continue through high school graduation unless certain factors are met. Colorado uses an equitable distribution of property model. Separate property is retained by the owner of the property, and gifts and inheritances are retained by those they were issued to. All other property obtained during the marriage is divided without consideration of fault based on the contribution of each spouse to the acquisition of the marital property, including the contribution of each spouse as homemaker, the value of each spouse's separate property, the economic circumstances of each spouse at the time the division of property is to become effective, including the desirability of awarding the family home or right to live in it to the spouse having custody of any children, and any increase or decrease in the value of the separate property of the spouse during the marriage, or the depletion of the separate property for marital purposes. Either spouse may be awarded support for a just time period, without regard to marital fault. If the spouse's combined income is over $75,000, the monthly temporary maintenance to the lower earning spouse will be 40% of the higher earning spouse's income less 50% of the lower earning spouse's income. If the spouse's combined income is over $75,000, maintenance is only allowed if the spouse seeking maintenance lacks sufficient property to provide for his or her reasonable needs, is unable to support himself or herself through appropriate employment, or has custody of a child, and the circumstances are such that the spouse should not be required to seek employment outside the home. For couples with over $75,000 joint income, the award of maintenance is based upon the time necessary to acquire sufficient education and training to enable the spouse to find appropriate employment and that spouse's future earning capacity, the standard of living established during the marriage, the duration of the marriage, the ability of the spouse from whom support is sought to meet his or her needs while meeting those of the spouse seeking support, the financial resources of the spouse seeking maintenance, including marital property apportioned to such spouse, and such spouse's ability to meet his or her needs independently, the age of the spouses, the physical and emotional conditions of the spouses, and any custodial and child support responsibilities. Maintenance payments may be paid directly to the court for distribution to the spouse. The court may appoint a marriage counselor in any dissolution of marriage or legal separation proceedings at the request of either spouse or their attorney or by the court, and delay the proceedings for 30 to 60 days to allow for counseling. In addition, the court may order a parent of a child under 18 years of age to attend a program concerning the impact of separation and dissolution on children. Finally, a court may appoint an arbitrator to resolve disputes between parents concerning child support and custody. Visit us today at www.mydivorcepapers.com and click on Colorado at the bottom of the page. Let mydivorcepapers.com help you file for divorce today.